Alrighty, we're live. Good afternoon, Facebook. Happy Wednesday. Raja Tayyeh, broker owner of Fit Realty Services, and I'm pumped today to bring Nadia Javaid, attorney at law, that's going to share with us something very important, very timely. We're going to talk about what is estate planning, right? Like a lot of people, including myself, we think, oh, we can wait for this when we get old, right? When we build all the wealth, we've got so much time. And now more than ever, you can take life for granted, right? So it's very important to think about the importance of estate planning, will, trust, power of attorney, etc. So I asked Nadia if, first of all, Nadia, thank you very much for, taking your time and sharing with the audience the importance of it and what those are, how they can be set. And I really appreciate your time. Thank you very much for jumping in. So I'm just going to turn it to Nadia, and let's start with what is estate planning.
Okay. Thank you, Raja. It's a pleasure to be here with you and with Fit Realty. So like Raja said, my name is Nadia. I am a licensed attorney in the state of North Dakota, and I want to put a disclaimer out there that the information that I'm sharing here today is for educational purposes. It's not legal advice. I would encourage you to see an attorney in your jurisdiction, in your state, if you have further questions or you like legal assistance. So yeah, estate planning is very important. It is a very touchy subject because when you think about it, or when people generally think about it, they associate it with death. A lot of the times they feel that, estate planning is going to come after do they have to plan it? They have to discuss death, where the assets will go, who will handle the assets. So there are various avenues how you can move your assets and what you can do with your assets and who you can give your assets to. So we can start off with questions. If you have any questions, we can take it from there.
Perfect. Yeah, I would just go with, very, very basics, right? ABCs of, the estate planning, especially will, possibly trust, possibly power of attorney, right? And again, it's misconception of people thinking, oh, hang on, I'm not dying, I'm still here, right? I'm not going nowhere, right? It's not really, because you never know. Like there's no guarantee, right? Yesterday has passed, today is okay, but tomorrow is not guaranteed. So it's always good to plan in advance. So let's start with the will, right? How can we set it up? What's a will in general?
Sure. So I'll backtrack a little before I go to will. So estate planning is basically a process. It's a roadmap that you create for yourself while you're living, and you basically, determine how your assets will be distributed, who will get your assets while you're living, and then when you're actually dead. So this way, the families are not fighting over the assets. The state law or the government is not telling how the assets will be distributed, who will take care of your kids if you have minor children. So that's the important aspect of estate planning. It's just not for old people, it's actually for young people as well. Now, to head into what is will. Will is basically a legal document that defines who is going to take care of your assets, and then if you have minor children, who's going to be the legal guardian of your minor children. If you die without a will, once again, the state determines, what's going to happen with your assets, who's going to take care of your kids. And the will generally has 3 to 4 parties. One, the testator, which is you create a will, you create this document, and then their beneficiaries, those are the people who you're giving your assets to. The third person is the executor or the trustee, and that's the person who will basically move forward with the assets and distribute them. The fourth person only comes into play when you have minor children and you have assigned someone, you spoke with them, you asked them if they would be the guardians of the children in the event both parents die. Then the guardian comes into play as well, and you assign the guardianship of your children to a guardian. Now, in order for a will to be valid, you have to, and enforceable, you have to make sure that you revoke all the previous wills. If you don't have any, that's well and good. And also when you're signing it, you're aware of your bounties. You're aware and you have the knowledge of what you're assigning and who you're assigning it to. So that's where the mental capacity test comes in. It doesn't, you don't necessarily have to be fully capacitated, but you need to be aware of your surroundings. So when I sit down and execute a will with a client, I usually ask them questions about, do they know what document they're signing? Who are the beneficiaries? Do they understand what they're giving to and who they're giving to? The date they're in, the year, just general basic questions to determine their ability to, see that they're competent enough to sign the will. Now, each state has their own law. Generally, when you execute a will, obviously the testator has to sign it. And then you also have to have two witnesses and a notary public, or two witnesses or a notary public. So it's an and or process depending on where you are in the country. Each state has its own law. However, if you don't want to type up a fancy will, you can handwrite the will. There is a thing called holographic will. It's valid as long as, it's handwritten and it's signed by you. Do you have any follow-up questions?
I think great point you brought up is not only regarding the assets, but also the minors, right? I think that's really huge, and people should really think about it, right? Because you never know, accidents happens, right? Car accidents, right? Diseases, right? So it's very important to really plan in advance to see if you have minors, who do you want the kids to live with, right? So I think that was a really, really great point. Would everything be in one single will with the assets and with the minors, or would it be like two separate wills?
Yes, so it'll be just one will. You can't have two separate wills. It'll be one document and it'll lay out everything. Now, it'll start off with, how your assets will be distributed, and then you can have the guardianship clause in there to assign who the guardian will be of the children. It's all in one document. Now, this is the important thing. When you want someone to be a guardian of your children, make sure you ask them. And then you also have a successor guardian. If you don't have a successor guardian, and let's say that the guardian that you put in there also passes away, or he is not, or she is not capable of taking care of the children at that point in life. So you want to have a successor. And the same goes to an executor or the trustee of the will. Make sure you have a successor. You don't necessarily need 3 or 4 or 5 people, but just have one successor. So this way, in the event that the first person that you pick is unable to do the job, the second person is there to take care of the job. And now, this is a very brief, generic information about the will. There is a lot more that goes into the will. You can do funeral plannings, you can do specific gifts. However, I do want to outline that insurance and payable on death accounts, those generally don't go into the will. So let's say if you have life insurance and you have designated beneficiaries in your life insurance, that will not pass through your will. That will actually just pass through the insurance carrier or the provider, and they'll give the money or the assets to the beneficiary you designated. Now, it's always a good idea to review your will every now and then, every few years, to make sure that if you had more kids, those children are included. If you're changing your beneficiaries and, or you're adding more assets, there are various different ways of doing it. You can have a codicil, you can have a list, but it's always good to review it. That's the takeaway from it.
Yeah, makes sense. Makes sense. So now, what's just for the audience, what's like the average cost of a will, and how long would it take the whole process to put one in place?
So the cost is dependable. If you're just, it depends on your assets too. If you want the very basic generic will, it can range anywhere from $350 to $1,000, depending on where you are. Obviously, what part of the country you're living in, and then also what kind of provisions and clause you're looking for in your will. Now, if you want a very detailed will with a lot of assets, with a lot of beneficiaries, and then, add provisions that are going to be a lot more complex than just typing up a will, then obviously the cost will increase.
Got it. Got it. Now, what happens if, God forbid, you pass and you don't have a will or you don't have a estate planning in place? How would that play out?
Yeah, if you die without a will, if you don't have that many assets, it's usually not a problem. If you're married, your spouse usually ends up taking the assets with minor children. Each state has different laws, but generally that's how it happens. That's what they usually do. The spouse gets everything. If you're not married and you have children, then the assets are distributed among the children, but it's usually like the state law that determines how the assets will be distributed and how your debts will be paid. That's the other thing that we should talk about. So if you do have debt and you have mortgages, loans, they do get paid first from your estate, and then the assets gets distributed to your family.
Gotcha. Gotcha. Appreciate that. Now let's move on to a trust. I know that's a little more complex, right? But give it to us in a nutshell. The difference between a will and a trust.
Sure. Yeah, trust is very complicated. Here, I would say, when you're ready to make a trust, you should speak to an attorney, sit down with them and a financial advisor, and basically go into depth and detail to determine what kind of trust you're looking for, because there are so many different kind of trusts that you can do. The most common one is a living trust. There is a revocable trust within the living trust and an irrevocable trust. Now, generally, what you can do is you can have a will with a pour over will. What it basically means is that when you die with the will, and then your assets upon your death will be transferred into the trust. That's one way of doing it. And then the other way of doing trust is, okay, so the purpose of the trust, let's just backtrack. The purpose of the trust is to basically centralize all your assets into one place where you are the creator of the trust. And then you can also be the trustee. And then you'll have beneficiaries who will benefit from the trust. You can put yourself as a beneficiary. However, you need to have more than one beneficiary if you're adding yourself as a beneficiary. I know it's confusing, it's complex. That's why I said it's best to, when you're ready to create a trust, it's best to go sit with your financial advisor and an attorney in your jurisdiction to discuss your options as to how you can go about creating a trust. And the revocable trust doesn't protect your assets against certain creditors. However, irrevocable trust does. And irrevocable trust is a trust that you cannot really go back and change. There are ways you can change it, but the criteria is very strict, and it's very it's basically to protect the beneficiaries and the assets. Whereas the revocable trust, you can revoke it at any time.
Gotcha. Perfect. So it seems like that the will is much more simple for someone with not that many assets. The trust is more complex for someone who's got more assets or who wants to still have a control over the assets, right? So that's good. Right. So basically, you will recommend an estate attorney, right? Probably someone who specializes in estate planning, not just a regular attorney. Just go to a specialist.
Exactly. I mean, I would recommend go through an wills and estates attorney to do that if you have a lot of assets or your assets are a lot more complex. But if you just have a home and a couple of bank accounts or investment property, then you go to an attorney. They should be able to assist you with the will. However, when you want to create a trust, I would say get a financial advisor with an attorney. And they do get pricey.
The trusts.
The trust.
Yes. Yeah, that goes into thousands of dollars. Yeah, right. I've had some clients, 10,000, 15,000, 20,000. Yeah, it depends on the complexity of the trust.
That's right. And it's basically a contract at the end of the day, a contract between the creator, the beneficiary, and the trustee. The trustee is the person who's going to handle the assets and distribute them the way the creator wants the assets to be distributed among the beneficiaries.
Got it. Perfect. Now, power of attorney, also very, very important, right? Can you elaborate on power of attorney?
Yes. So there are various different kind of power of attorneys that are out there. There are power of attorneys that are general. They're all inclusive. They cover everything, your financial, your tax, your rental property, your mortgages. It's basically a power of attorney is a document where you're giving an authority to act on your behalf, stand in your shoes and be you while you cannot do that act. Now, there are various different ways you can draft a document. You can have a specific power of attorney where you're just allowing a person to act on your behalf for a certain thing or a certain act or an action, or you can do a general one where they can do a whole bunch of different things, such as like paying your bills, handling your bank accounts, taking care of your mortgage, your taxes. And when you're doing that, you want to because it's a lot of power you're giving to a third person. And that person is called attorney in fact or an agent, depending on where you are in the country. And you want to make sure that you trust the person. I mean, there are laws that protect you. There are fiduciary duties and things like that that apply to the attorney in fact. But initially, you want to make sure that you trust the person with your assets and the duties and the decisions you're delegating to them. Now, within the power of attorney, there is also durable power of attorneys, and they're also known as the healthcare directives, and these fall under the advanced directives. That's for medical purposes. So those you need to
would it be like a health proxy? We talk about like a health proxy?
Right. There are different names depending on where you are, but advanced directives have living wills, and they also have healthcare directives or health proxies or durable power of attorneys. And they're basically designed to provide the medical treatment and care that you need while you're living, but unable to make decisions for yourself. Now, there is a difference between a living will and healthcare directive or the durable power of attorney. The living will is basically you provide a roadmap to your loved ones, your family members, your doctors, how you want to get treated when you're unable to make a decision. You know, do you want to be resuscitated? You do not want to be resuscitated in the event that you're unable to make that decision for you. Do you want to be on the ventilator? Do you want to refuse medical treatment if you're at a stage where you will not recover? So those are the things that you have to discuss with your family and with your physician, obviously, to lay out your concerns and then share what is it that you want to do at one point in life. I would always, when clients come in for a living will, I tell them, you know what, first discuss with your family and your loved ones, and then we can draft the living will based on the information that you're going to give me. Whereas the healthcare directive is slightly different. What it does is it basically gives the power, as the name has it in itself, a durable power of attorney. It gives the power to a third person where you select someone, an attorney in fact or an agent, to make the medical decisions for you. It's always a good idea to have a successor in there too, especially in the event that, the first person is unable to do it for one reason or another, then the second person can step up and make those decisions. However, healthcare directives end when you die. And then same applies to the power of attorney. The power of attorney, whether it's general or specific for your financial purposes, it also terminates when you die, or you can set a date to revoke it. Now, each state has different laws with power of attorney. Some states require that you file the power of attorney with the county clerk's office to make sure that it's on the file, it's on the record, and then in the event you need a certified copy or the doctors require a certified copy, you can pull that at any time and give it to them.
Perfect, good stuff. So basically, from what I understand, the power of attorney is great for when you have, let's say, elderly parents, right? The health proxy, same way, right? You'll be able to collect information from the doctors, be able to pick up, subscription, prescription, right? anything important on behalf of their parents who cannot make a decision anymore, right? Gotcha. So it's super, super important. And especially now, right? We have more time. Everybody's home, right? So I think it's a really, really good time to look into setting up the estate planning and thinking exactly, what if, right? How can, yeah, go ahead.
I mean, it shouldn't take a pandemic to for us to come to realize, hey, we need these documents in order. It should be in order. When you have minor children, it should be in order because you want to secure the future of your minor children. If you're at an age where you're elderly, you want to make sure that all your assets and your things are in order. So this way, in the event you die, your family is not fighting over your assets. Sometimes it's not about money. Sometimes it's about sentiment. You dad or mom may have some painting or an artifact that is worthless. However, it holds a lot of sentiment. And now the children are fighting over that because one wants it and the other one believes that dad wanted him to have it. So it's always good to plan it out. So this way there are no issues in the future within the family or the heirs of the person.
Perfect. Yeah, that makes so much sense. And I feel like people are always busy, right? People are always on the move, right? And people always subconsciously think, oh, look, I've got time. I can always plan for it, right? Nothing happens. I'm healthy, right? So especially now, yeah, we're going through a pandemic, yet we have a lot of time. So I think it's a really great time for everybody to look into this and start planning in advance. Any closing thoughts?
Yeah, I mean, so it is a good time to plan it, but then with stay at home orders, shelters in place, it might be hard to like go in person and do this stuff. So there are, the services are available online. You can do your own search and then reach out to, I'm not promoting here, I'm not advertising anyone here, but LegalZoom, Legal Shield, there are different online lawyers available. Also within your community, you can reach out to them. A lot of the attorneys I know, even myself, we have been doing meetings through FaceTime or Skype and discuss it. Now, to execute the will, you do need witnesses, or a power of attorney, you do need witnesses, and you do need a notary public. So make an arrangement, with the attorney, how you can sign those documents.
Gotcha. So maybe not doing it completely, but at least plan for it, right?
That's right.
Who the assets gonna go to, who the kids are gonna go to, right? Who the sentimental picture will go to, right? At least kind of plan for it. Sit down with your wife, sit down with your loved ones, sit down with your kids, and have a real discussion, real time,
Right.
real discussion, and say, look, it's time to put an estate planning in place, plan it out, do some research online, and then once things opens up, go ahead and execute it.
Right. And then if someone is sick at this time and they don't think they're going to make it through before the pandemic is over or before things get a lot
great point.
easier, you should always write your wishes. Handwrite them, type them up, write your wishes on a piece of paper, sign it. So in the event you die, at least your family knows what was it that you wanted to do.
Gotcha. So they can be just typed and just signed and just dated.
Right. I'm
That's
not saying it's a legal document. I'm not saying it's going to hold any value in court. That the court will determine depending on where you are in the country. But at least your family will know what your wishes are.
Right. That's the most important thing. Okay, cool. Any final thoughts?
No, I mean, if anyone has questions, they can email me or they can call me. You can put my information on there. I'll text it to you.
Yeah, we'll put your information in the comments. Thank you so much for your time.
Thank you, Raja. It was a pleasure.
Thank you so much. We'll hope to see you soon, okay?
Yes.
All the best to the family. Stay safe. Take care of yourself.
Thank you. You too.
All right, everybody. Here you have it. Talk to you later. Nadia Javaid, attorney at law.